right, welcome back, everyone. So now we will rejoin for session 2, translating leaked information into legal action, challenges, and opportunities. And so really now our goal is to kind of take our, as I said, our understanding of leaks and think more directly about their use in the judicial process. So the first question I really wanted to start us off with is a sort of kind of the basic, how to use this information. We've gotten a picture, as we noted many times in the first session, about the vast quantity of material that's really now available in the form of leaks. So the question really is how do investigative bodies, government bodies, effectively explore this information? How do they go about figuring out what's significant and how they might use it for investigations or legal actions? And is there assistance that journalists can give in this specific regard, right? The ability of the judicial system, right, to work with this vast body of information. So starting us off with that how to use question, and Mihail, I will turn right to you.
Thank you, Diane. I'm going to speak because I have to go in 5 minutes. First of all, I would like to thank the National Institute of Justice and the other organizers for this opportunity to have an open discussion with investigative journalists and legal practitioners on this topic. As I'm a liaison prosecutor, I want to quite short to say about the cross-border investigation related to the transnational leaks which were supported by Eurojust. A good example is football leaks. There was a case opened by the French National Desk in 2018 at Eurojust based on a request made by Parquet National Financier. A coordination meeting between 10 countries was organized at Eurojust. As a result, was signed a JIT agreement. The case consists that the Portuguese national offered between 2016 and 2018 the German news magazine 70 million documents, various issues such as salaries of famous football players, also about financial frauds committed by the biggest European football clubs, sport federation, and companies. In this case, prosecutors investigated money laundering and aggravated fiscal fraud committed by an organized crime group. In the judicial practice of the Republic of Moldova, whistleblowers' statement or leaks from journalistic investigation represent an important source for starting criminal investigation in cases when we don't have a complaint according our criminal procedure code. Often people are afraid to complain about the illegal behavior of high-ranking officials. It is a reason why the leaks and the whistleblowers are crucial in cases with the involvement of high-ranking officials. In Moldova, since 2018, we have a law that protects whistleblowers from any revenge. According to our criminal proceeding code, we have the possibility to protect whistleblowers when they make statements in criminal cases. If it is considered that the whistleblower's life or bodily integrity is in danger, he can be heard by the technical means in place other than the one where the court hearing takes place. His image or voice may be distorted so that he is not recognized. In the same way, his identity data is changed. Thank you.
Thank you very much. I'm so glad you were able to get those remarks in before you needed to leave. So again, I'd like to open it up for any observations. Mario, there you go.
Thank you, Diane. So I think your question was how can data collected by whistleblowers, how can they be used by the judicial authorities, by the investigative authorities? So I would like to give you right now the state of the art here within the Italian legal system. So with regard to, we need to make a distinction between tax assessment and criminal trial. Within the tax, with regard to tax assessment, it is legitimate to use any element with a circumstantial value. So with the exception of those cases where a breach of fundamental right is taken into consideration. So the Italian Supreme Court stated that, for example, the findings from the so-called Falciani list can be used with regard to the tax assessment, and the tax authorities can base their claim on those documents. Things change in the criminal perspective because, of course, personal freedom is at stake, and the provisions on anonymous documents apply to these cases. So these are documents formed through an illegal collection of information, and so they cannot constitute evidence of the facts alleged in them in a criminal trial. They can constitute only investigative cues, i.e. the starting point for more in-depth financial investigations. The provision on anonymous documents is the reason why in my first intervention I stressed the importance of regulation, because I hope that Italy will soon implement the European Union Directive on the protection of whistleblowers, because as we all know, the activity of whistleblowers is always a delicate balance between public and private interests. And since the famous, the leading case, Guja versus Moldova, within the European Union, a set of criteria for being granted the status of whistleblowers has been established. So this is really important. This is, I think, the key topic right now, the need for a regulation, because otherwise anonymity is going to be the main way adopted by whistleblowers. But this way affects the use of documents, at least in the criminal trial. Thank you.
Thank you. Tom.
Well, for us, the Government Accountability Project, the process of turning the leaked information into usable evidence is very basic. It's finding trustworthy partners in government law enforcement to team up with. Now, we're generally considered, watchdogs against the government, but some of the most effective partnerships in my professional life for decades have been with FBI or agency criminal investigators. The goal is to get the evidence into their record, and then it can continue through the process. But the partnership can be treacherous because in our experience, government investigators very frequently just aren't that interested, or they don't have the time to do all the careful screening of information to make sure that the facts that they're using and confronting wrongdoers with can't be traced back to the anonymous whistleblower. And the SEC in our country, I think, has a very good model for preserving confidentiality. If you want to make an anonymous report, you have to do it through a lawyer. The SEC doesn't talk to the whistleblower. They just work with the whistleblower's lawyer, whose primary mission is going to be protecting the client and making sure that the information doesn't get traced back to them.
Thank you. Glenn.
Since I'm not a legal expert, I'll just keep this very short, but I think that there is a significant delta between those that have the information, and that could be a lawyer or a journalist, and those that can understand the information, because oftentimes a data donation or data dump will be a lot of technical information. And I think that one of the areas of opportunity, so I'm not going to give any solutions or answers, just more problems. I think one of the areas of opportunity is, how do we connect those with the technical proficiency with those with the capability of doing something with the information in a legal context or some other context. And I think that some of the challenges there are trust. Who can you trust this information with? can you trust that they're going to give the full context back to you? So it's something that I've seen in or heard with other discussions, but what are those avenues or platforms which we can use to connect people that can help each other in an effective way? Because this is a big problem in when we have increasingly unstructured and data and lots of it.
Thank you. Mary.
Yes, thank you. The question of how can data from whistleblowers be best leveraged and used by prosecutors, I think is a great one, because as Tom referenced, we do have several models in the United States, starting actually with the False Claims Act, which was a Civil War statute that really tries to create a public-private partnership where whistleblowers can bring information to the government, and then actually they are parties to the litigation. They are plaintiffs standing in the shoes of the government. And so one of the ways you can leverage whistleblower data is to actually leverage the law firms that sit behind, like mine, that sit behind these whistleblowers, which is that this information, these data dumps often go to the hands of very overworked and underpaid government prosecutors. And they are going up against some of the largest corporations in the world that are very well financed. And so one of the benefits of having whistleblowers and incentivized whistleblowers and their counsel is that you can start to enlist the help of not just the whistleblowers who, as Glenn was talking about, help you translate the data. They are the experts. They're typically the insiders who can help the government make sense of, a foreign language. What does all this stuff mean to be, within this particular corporation? Every corporation uses its lingo. It can be incredibly technical. So your whistleblower is your guide to that information. Your whistleblower's lawyers are some of the bodies and boots on the ground to help the government sort through information. Hopefully the whistleblower has given enough information to trigger a subpoena by the government. The government then gets more and more data, and they still are a small team. And often, the defense strategy is to bury people and put the needle in the haystack and bury you with information. So it can be really helpful to have that. So I wanted to elucidate that, because that's a tool that a lot of people are not aware of. Is not just the role of the whistleblower, but it's the role of the whistleblower lawyer in supporting and being a key member of the prosecutorial team, at least in the United States. And I think the other important really big piece here, again, as I know Soren talked about the LIBOR scandal, and there was a whistleblower there who helped reveal, at least participated in the CFTC's whistleblower reward program, actually received close to a $200 million reward for exposing the manipulation of the LIBOR rate across banks throughout Europe and the United States. And so that is a really interesting model also, that if you want whistleblowers, it's very important to do what the SEC, CFTC has done, which is set up offices of the whistleblower that are clearly demarked with signposts on how you can safely report and upload this information. You can do it anonymously, because I think it's one thing to say we welcome whistleblower information and have a hotline, and the whistleblower having no faith that that information will ever get used. And I do think that one of the benefits of the reward programs that the U.S. agencies have set up is that it instills confidence in whistleblowers that they know where to report. There are a group of people who are staffed in an office of the whistleblower who are obligated to report that information, to analyze it, and if it is, meets the test, to pass it over to the enforcement team. So I think these are really important mechanisms that we've had success in the United States in setting up in order to leverage that information. So I would encourage folks, and I know that there's a strong resistance to an idea that we incentivize whistleblowers in the United States. There's a big cultural divide that certainly from my time in the UK, where people feel like you should blow the whistle because it's the right thing to do, not because there's a financial incentive. Believe it or not, we're starting to see a real thawing in the UK with the Labour Party, including rewards as part of their party platform. The new head of the SFO in the Serious Frauds Office in the UK, Nick F. Graves, has called for rewards. RUSI, one of the government think tanks, is about to issue reports that have full-throated support for that. So Canada already uses this approach, so it's not just an American idea. It can be Commonwealth countries that bring it as well. But I don't want to understate. I think it's important to not lose the role of the whistleblower, properly incentivized, properly protected, in helping prosecutors not just give them the data, but interpret the data and have the bodies and the reinforcements to help them actually prosecute a case and sift through it.
Thank you very much. Amira.
Thank you. Maybe to join also what was told before by Mario, I think it's important to make the difference between administrative procedure and judicial procedures. Now, in OLAF, we are somewhere between the two because we are an administrative investigative body. However, our task is to investigate fraud, corruption, and other irregularities. Since recently, we also have a new actor in the institutional framework, which is the European Public Prosecutor's Office, with which we work together. And where there are also other entities, I think, for example, about competition authorities. And here what we see is that the legislation is somehow sectoral and there is no interlinking between them. So, for example, you can have a whistleblower protection in a competition procedure, but when it appears that it's also at the same time EU fraud, it comes to OLAF, we don't have the same protection procedures. Then it goes to the criminal, it's again a new procedure. So there is a worry from the whistleblower on how they will be protected also in the follow-up procedures. On the side of how to use the information, I think it's important to make the difference between information gathering and evidence gathering. So at my level, I absolutely see that we could not do without the leaks and investigative journalism on the information gathering side. On the other side, it is not sufficient for us to say that, to establish that there was fraudulent activity, for example. So we have to go then with our tools to collect evidence, and sometime also with judicial tools, the prosecutor will go on their side. So we have to think about how to harmonize all those interactions, but on my opinion, it's absolutely crucial to understand that without that information, we would miss a lot of detection. So I always repeat also that journalists should also think about, or whistleblower law firms should think about that we don't have our own initiative. We cannot do phishing activity. Okay, there is sometime framed analysis work, but we cannot do our own cases. So this is why we rely on those who come to us. And sometimes it's not enough. We know that in the newspapers that there is awareness raising about some issues, but maybe we will not open on our own initiative a case. A prosecutor also will not open just because he's reading the newspapers. So there should be an act which is somehow bringing it to the authority, a denunciation or a formal submission to OLAF. And when this is done, then we take it over and then we begin collecting evidence with our own tools. So yes, this is what I wanted to clarify, that it's important for us that it comes formally to us. Thank you.
Thank you. Samantha.
there is this really interesting tool called Eyewitness, which was initiated by the International Bar Association. And Eyewitness allows people who are witnessing war crimes and atrocities, human rights violations of the sort, to document these things and take their evidence and submit it. And then it goes through a process utilizing a lot of its pro bono lawyers from big law firms, but also I think private sector and other professionals engaged in verifying the authenticity of the evidence. And then they will submit it, and this can be used for investigations, but it also can be submitted to the courts, including the International Criminal Court, and be then used in legal proceedings. Now, I think that, with the rise, of course, in AI technology as well, but the use of apps and technology obviously has been around for a long time. And I think if there was a medium, and which includes, lawyers for whistleblowers themselves and journalists as part of that, but for verifying the authenticity of the evidence and understanding the channels that this evidence needs to go to, or even using it in court, or even being able to go like Eyewitness does to court, I believe, and even testify to the authenticity of the evidence, that these leaks of information can be more impactful. Plus, it really having something like that at the hands of really anyone who's aware and can access this service. I think that it really allows would be whistleblowers who have a piece of evidence to come forward with that, and a lot of the times it's not necessarily one giant leak of data. It can be bits and pieces from different people. So I think if they had this sort of program available for reporting things like fraud, tax evasion, bribery, etc., which there's report a bribe, I think is another, but I think more tools like this and funding to support that would be really helpful for judges who are trying to use this information in a court case and need to have some level of credibility that is ascribed to the evidence.
Thank you. Veronica.
Yes, hi everyone. I am currently the chief of the Anti-Corruption Prosecution Office of Moldova, but previously I was also a federal prosecutor in the United States and worked as a lawyer and attorney in the United States as well. So I kind of have a perspective from two very different legal systems. And one thing that I wanted to add, I very much agree with Mary's comment about, how do we try to incentivize some of these things, and having worked on civil litigation cases in the United States where, a case started because a whistleblower reported it. So for example, something like a False Claims Act case. So someone inside that worked at a particular pharmaceutical company notified authorities that really that pharmaceutical company was engaging in a big False Claims Act scheme where they were essentially trying to get reimbursements for things that they shouldn't have. And that particular whistleblower stood to gain tens of millions of dollars for coming forward. And without those types of financial incentives, it's really difficult to have people that want to assume that type of responsibility. It often means you're going to be let go from that place in that job, and also maybe have other reputational or professional consequences as a result. So without having some really concrete, for obviously protections are important, but also maybe some type of incentive more so than just protection. And in general, I think one of the biggest differences that I've noticed in the Moldovan criminal sort of system compared to the common law US system is a lack of tools to offer for cooperating witnesses. So a prosecutor in the United States has a lot more discretion to negotiate with people that are willing to cooperate proactively and give information, whereas in Moldova and other countries in this part of the world, that's a much more limited concept, and that's really a big struggle, especially for corruption cases or cases where incentives really are on both sides to keep these things secret. One thing in Moldova that we rely on quite often is investigative journalist reporting. I think we here, the atmosphere in Moldova for a long time has had a level of mistrust in the judicial process and the government. And so people have oftentimes more faith in a journalist doing the right thing with that information than the authorities. And so we try to be proactive and sort of following up. And like some others have mentioned, you know, the leak or the initial source is a starting point. And then obviously we have to verify and confirm it through many other sources. But we have many examples in Moldova of cases that began that way and that we were then able to document through other ways. So certainly so important to kind of foster as an environment and a legal framework where we are providing incentives for people to come forward and do that thing, not just because it's the morally right thing to do, but hopefully, you know, giving them assurances that makes that the right choice so that we can bring these things to the surface and hold people responsible that are committing these types of crimes.
Thank you very much. Ashu.
Yeah, I'm going to be the voice of controversy again. I hope, and I don't want to be. But speaking to corporate investigators, there is that, again, I mentioned the legal versus moral discussion. There's also this kind of philosophical discussion as well. So when someone joins a corporation, they sign a code of conduct, they attest to it, and part of that code of conduct is if you see something wrong, you speak up. And so the reason why we have leaks is people don't feel safe to speak up, and so then they leak the information. The financial incentive is there sometimes not to just reward someone for doing this, but that person's career life was now at risk, and they need to pay their bills, they need to feed their family, and so they need that assurance. But it's not easy to make that payment because a conviction has to happen, and for the conviction that has to happen, those who worked in prosecution know that you have to be very watertight in how your evidence has been obtained, and you need to be absolutely sure about the safety of that evidence. Now, if evidence is being leaked and everyone has got their hands and paws all over it, from a judicial point of view, that evidence can be tainted. And so I think that a lot of safeguard, a lot of thinking needs to be put in place if we are saying to ourselves that leaked information is more than just open source intelligence. And that's the key as well, because there is a lot of open source intelligence out there. And corporate investigators now will go to the ICIJ website. Now, as a matter of fact, we'll put a customer in there. Oh, the name is in there. I perhaps don't want to do business with them. Or maybe I do, but I'll risk accept it. So I think that there's a lot more thinking involved, just at a grassroots level, of what evidence are we actually going to accept from a prosecution standpoint. Are we able to defend the safety of that? And to the other point, if it's been obtained illegally, as in GDPR has been breached for that information to come out based on the moral assumption that this needs to come out for the public, is that an amnesty situation where we allow that to happen? So, I'm very much for rewarding whistleblowers. I'm very much for, protecting them and getting this information out there. But I also don't want them to risk everything only to fall foul at the actual prosecution point and then have no safeguards at all.
Thank you. Tom.
I just want to put in perspective the rewards and the different types of them. Depending on the awards, receiving an award to avoid financial disaster is like expecting to pay your bills by winning the lottery. Very, very small percentage of people receive them. So I think there are some models that can be more effective in terms of the financial consequences of taking the risk to blow the whistle. One is by adding punitive damages into the rights. Almost all of the world's whistleblower laws say that if you win, you get back to even. And you really can't get back to even in terms of a lot of the indirect consequences. The other is, in my opinion, and in track record in terms of having an impact on financial crimes, the False Claims Act is much better in both directions. The one where whistleblowers are deputized to file whistleblowing lawsuits, and then if they win the lawsuit, they get a minimum of 15% of treble damage recovery. That doesn't draw the backlash against whistleblowers that reward programs have been the catalyst for, because they're fighting and winning the battle on behalf of the taxpayers rather than getting paid off for whispering in the government's ear. It's had far greater recoveries than the rewards programs, but it's the same basic concept that the whistleblower who risks everything is entitled to share in the benefits that they created.
Thank you. So I would like to turn to a next question. It's a little bit targeted. This is about old data. And a number of you have referenced some very important, but now older leaks. Think Panama Papers or others. And the question is, how do investigators and prosecutors really assess the relevance and the reliability of older leaked data? And whether that's to use it or incorporate it into ongoing investigations, or maybe to form the basis today of an entirely new investigation. So really a question about how to be using and assessing older leaked data. Tom?
I'll take a crack at it because it's something that you determine on a case-by-case basis, and I don't think there is a consistent rule. It depends on its relevance, but it can be very relevant to show a pattern of misconduct, that whatever is the immediate focus of the investigation is not an aberration or out of character. It can show the motives for misconduct. It's not going to be direct evidence of the crime, but it can really create the proper context.
Thank you. Amira?
I don't think there is a date of preemption on the evidences. So for me, it depends on the subject of the investigation. If I am investigating something where a fact which happened at that time is still relevant, then I will, of course, take it into consideration. So for me, there is no problem. The problem can be if I want to collect it a second time, recollect the same data, but with tools which can be then considered as evidence, then maybe it is possible that the evidence is already destroyed. So if the quality of that data is not sufficient to prove without any doubt from where the information comes, then it can be, of course, problematic to reacquire the same data. But otherwise, I wouldn't have any problem to consider older data.
Thank you. Ashu?
I think from a corporate perspective, corporates have to abide by data retention rules, particularly the whistleblowing directive. But a corporate investigator, when they get a matter, will look at related case history, and that might mean going on and looking at a database of leaked information from maybe 9 years ago, but they'll have nothing to correlate it to because the governments have got data retention rules and they may have deleted that information. So there is a challenge sometimes when dealing with that older information. The other aspect of it is that all information still safe? That is another issue. But to Tom's point, contextually, it can still help you in your process. But I think data retention rules might challenge that particular process.
Thank you. For those of you following along with sort of our questions, I'm going to skip number 3 about the synergies because I feel we picked that up a bit both in Mary's response, looking at the array of formal programs to bring whistleblowers and their counsel into a relationship with the government potentially and in assessing information, as well as Tom's sort of counterpoint about being careful with partners that you join with in the process. So I'm going to bring us to number 4, and we did lead off with a little bit of a conversation on cross-border, but I want to come back to that and really ask what you see or have experienced as the challenges that investigative authorities face when they're conducting cross-border investigations related to essentially transnational leaks. Vasilios.
Yes, thank you. Well, in such cases, I think that well, a major point of concern is the use of evidence in the context of judicial cooperation, where there is also a specific principle, the principle of specialty, which should be respected in this regard. And this means that each state providing judicial assistance ties it to a specific offense and to a specific case. So it's not only about the use of evidence that is obtained through criminal acts, let's say, for example, through a violation of communications privacy or a breach of banking or professional secrecy or something like that. It's also a case where, let's say, the prescribed procedure is not followed correctly, which also results in the infringement of the defendant's defense rights. And this is also something that could be problematic in cases where, for example, the country from which the evidence is leaked would actually want, let's say, to protect the banking secrecy. And so in such cases, they say that we don't want this evidence to be used at your country. This could, under certain circumstances, be problematic according to the principle of specialty. I think that this is what we have also experienced in several cases. I think it shows also that things are not quite simple.
Thank you. Ashu.
Yeah, I mean, further to that point, I mean, the Panama Papers is a perfect example. So you would have a body such as the Department of Justice who would come along and say, well, they'll go to a bank and they say, I need to know that level of exposure you have to those individuals on that list. And I'm interested not just in US customers, I'm interested in any customer that's had any interest in American business or in American interests. But of course, Malaysia might turn around and say, well, no one must know anything about a Malaysian citizen. And so that puts the organization in a very tricky situation because you have Department of Justice saying, no, you're going to give us this information. And the Malaysian government's expectation is that no information will be shared. And of course, between governments, there's a memorandum of understanding when you're looking to investigate a citizen of a particular country. And quite often in these leaks, that is then attempts are made to bypass that just on the fact-finding stage that will then help the prosecution stage later. So that very much puts the corporations in a very much of a tricky situation. What do we share? How do we share? Some get by it just by using aggregate data rather than providing specific information about subjects of interest. But it does raise a lot of challenge. And when the Panama Papers hit, that was one of the hugest challenges that many of the banks went through at that time.
Thank you. Mario.
Thank you, Diane. So the question was about transnational investigations. Okay, the vast majority of investigations over economic crimes have a transnational dimension nowadays. With regard to leaked documents usually come from privileged tax countries. And so with regard to these countries, there is, I think that there are pros and cons. An advantage is that, for example, with regard to tax assessment, as I said earlier, tax authorities may base their claim even on a single piece of evidence if it is serious and precise. And data collected from whistleblowers, for example, in the case of the Falciani list, are deemed to be endowed with those features. And also there is a legal presumption in tax claim that investments and assets held in privileged tax countries are considered as undeclared and therefore unduly withheld from taxation. At the same time, there is a disadvantage because the international cooperation, judicial cooperation instruments with those countries, for example, I'm thinking about Panama, for example, they are weak. The instruments are not as strong as, for example, within the European Union. So if I submit a rogatory letter to Panama or to other countries, the outcome is not sure. And that is a problem. That's why it is important. This is the reason why it is important to strengthen international cooperation, both under the administrative and the criminal perspective.
Thank you. Samantha.
So I want to talk about kind of two things in the cases of whistleblowers and cross-border investigations. One is confidentiality and anonymity, because when it's important when dealing with the disclosure to an agency for investigation that the whistleblower's information and the privacy of those witnesses concerned be limited to those who have a need to know basis, and that there be internal controls set forth. And there's two things when cooperating in a cross-border investigation. Important one, I think, is that duty to warn the whistleblower and let them know, and franchise them in the process, even to decide at a potential later time, if this comes up, what information they're willing to share with this other jurisdiction. But also, really, it's important for the sending agency, who's cooperating and sharing with other law enforcement, to make sure that the same policies of need-to-know basis and that protective the technological tools are used for storing the information by the respective entity. So I think that there's a role by the agency to play in negotiating with and deciding who they will and will not cooperate with, depending on the level of protections they do or do not have available for the whistleblower, and that the chain of what the whistleblower has consented to and negotiated to in terms of their confidentiality and privacy is maintained. For instance, in subsequent prosecutions in other countries, there may be a point where someone who was confidential will not be confidential or anonymous anymore in those jurisdictions, who may have a right to prosecute, and depending on the instance in the case of the whistleblower and their vulnerabilities, that could be very dangerous to them. And so they should know what's potentially involved as much as possible, and enfranchise from the outset. Now, the next circumstance that I want to talk about is non-prosecution agreements. So the United States does accept, and encourages its Department of Justice, the Securities Exchange Commission, et cetera, disclosures from whistleblowers who don't have clean hands. And to an extent, the whistleblower who's bringing forward this information takes some level of risk involved if they don't have clean hands. But the point is to get the bigger fish, to get the evidence, not to have a perfect whistleblower. And so if they negotiate a non-prosecution agreement, it is important that in a cross-border investigation, that that the whistleblower in this case, that would not necessarily apply to this other jurisdiction, and the whistleblower really should have representation and be supported in negotiation of non-prosecution in these other jurisdictions when they discover that the whistleblower witnesses involved don't have totally clean hands. And so I think it's also going back actually to the same point, when identifying who are we cooperating with, really looking at their practices and approaches and how they respect and treat and protect their witnesses and whistleblowers, and they'd be very cautious. While of course also I don't want to say that it's not important to have transnational cooperation, which can be more effective and more powerful for the leakers and the whistleblowers themselves. But it has to be done very carefully and very mindfully. And we have to think very carefully about the jurisdictions that we're working with.
Thank you. Mary.
Yeah, building on what Samantha had to say, just wanted to underscore that the SEC program, CFTC programs in particular, actually anticipate this issue, that when a whistleblower submits a tip under one of those programs, that there's a strong likelihood that they may be, that information may be shared with a foreign jurisdiction for a cross-border investigation. And so in anticipating it, the financial protection, the financial safety net that whistleblowers are entitled to under these programs actually says that a whistleblower can receive 10 to 30%, not just of the fine that the SEC or CFTC imposes, but also a percentage of the fine that the foreign jurisdiction would impose in a related action. So interestingly, to go back to the example of the LIBOR manipulation case, the whistleblower actually divulged and revealed their identity. We know that they are a Deutsche Bank whistleblower who exposed the LIBOR manipulation. And in the SEC's and CFTC's press releases where they announced the payment of the reward to the whistleblower, they said the whistleblower received a percentage of both the fine that the American authorities imposed, but also the UK's Financial Conduct Authority. So it very much goes to Samantha's point, which is that every time a whistleblower's information is shared with a different foreign law enforcement agency, the risks to that whistleblower increase. And so therefore, there's a recognition in the Dodd-Frank Wall Street Reform Act whistleblower program statute to recognize that you should be compensated from that. Of course, if you're in the UK, it's kind of going to seem shocking to you that a whistleblower got a piece of the FCA's fine, even though it didn't come out of the FCA's pocket. So I think it is really interesting, and that obviously applies to jurisdictions that the U.S. regularly cooperates with, like the UK and other European agencies. I think those types of transnational investigations don't always extend to other jurisdictions as easily because of the fact that there aren't always the same levels of cooperation agreements.
Thank you. Stefano.
Yes, thanks, Diane. Just one remark that I want to add to what has been said so far. The transnational or cross-border dimension of financial crimes has already been highlighted by the previous participants. What I want to say with this brief intervention is that in the field of judicial cooperation, the role of the European Public Prosecutor Office is very relevant because as a public prosecutor office, we work as a single office. That means that we share the same objects. We set up the investigation since the early starting of it together. we don't cooperate, we work together as a single office. So the strategic decisions are being taken immediately in the first stage of the investigation, not at a later stage, just in the perspective of a cooperation, which is relevant for sure, but it's not the only one. And what makes the difference is this, to assess and establish the targets and the objectives of the investigation, which involves several and different European member states together since the early beginning of the activities, and that's a difference between the compared with the European field in judicial cooperation. We still haven't dealt so far with the leaks of data, at least not so relevant as ones that have been mentioned during the discussion. But what I want to say and what I want to share with you is that in the perspective and in the so-called EPPO, which is the acronym for European Public Prosecutor Office, we work in a complete different way, and we use different tools foreseen by the EU regulation for exchanging information and evidence. After having gathered and terminated the investigation, the assessment and the evaluation of evidence is subject to the national law. So the differences among different legal environments and different legal tradition and case law are relevant and must be taken into consideration. But at least in the investigative phase, I reckon, and also the first results of the first 3 years of operational activities of the European Public Prosecutor Office, I do believe that EPPO is already playing an important role as a game changer in the field of judicial cooperation, also and especially in the financial crimes, since our competence is limited to the offenses, criminal offenses, which have an impact on the financial interests of the European Union. Thanks.
Thank you. Sean?
Yes, thank you. Well, if we talk about the cross-border aspects of whistleblowing and leaking and journalism in this context, I'd just like to remind everyone that, of course, while we still have huge differences in jurisdiction and in the application of criminal law, also with regards to leaks, it is, of course, very important also to consider extradition aspects. That is, if, for example, the leaker and or the journalist could be subject to an extradition, it may be counterproductive in the long term to expose this individual to criminal prosecution in another jurisdiction, which I think is a very big risk of, well, having a sort of a chilling effect and preventing other people from leaking in the future.
Thank you very much. I've been just loving all of your interventions, so I've been very excited by our conversation. I know we're closing really on our time, so what I'm going to do is ask 3 remaining questions. They're sort of combined. So first, I want to combine questions 5 and 6 and move us from the investigative phase to legal proceedings. So we imagine legal proceedings are underway that are based in part on leaked information. And the question is what is, can be, should be the active role of journalists and or the leakers in legal proceedings themselves? So we've moved again past investigation and using the data, but now we're actually in legal proceedings. Stefano and Mary, your hands are up, but I'm not sure if you meant that. Mary, you had your hand up yet?
Yeah, I mean, I think the
Sorry.
whistleblower. Oh, sorry. I think whistleblower, the role of whistleblowers in the actual ongoing proceeding. I mean, my hope, and it's certainly been my experience in most of my cases, is that fortunately, the whistleblower's testimony isn't always as necessary because they've been corroborated by lots of other witnesses, especially in the context of American whistleblowers, where they have a financial incentive under various whistleblower programs. They're not ideal witnesses because they can be cross-examined saying, don't you have a financial interest in the outcome of this? Doesn't this somehow negatively impact your credibility? So there are very few cases where it's been a question of the whistleblower's word versus the company's, where the whistleblower themselves has become vital to the testimony. So for instance, our client, Tyler Schultz, who is one of the Theranos whistleblowers, never testified in Elizabeth Holmes' trial or Sunny Balwani's because there were so many other people who could attest to it. So I think the whistleblower can certainly serve as a witness, but depending on what program they participate in, sometimes they're not as strong as other witnesses. So they certainly can play a role and should play a role. We've had confidential informants for years play roles in government prosecutions, and people have to handle and deal with the fact that they are often incentivized to report.
Thank you. Tom.
Well, I think the partnership between whistleblowers and the media can play the same role during the trial as before it, being kind of watchdogs to hold the government enforcement agencies' feet to the fire. To illustrate, if whistleblowers provided significant evidence to prosecutors and they're not using it, if the whistleblowers provided that evidence to the media, they can write a story on it and kind of force the prosecutor's hand to stop ignoring that information. It's essentially blocking a monopoly on what the government chooses to enforce in the proceeding.
Thank you. Samantha.
In the United States, and I mean, I think this is the case in many different jurisdictions, you have media sources that are not funded very adequately. And then, of course, you have some that are. And, you know, leaks may go through different outlets that have different resources available. So, you know, the New York Times, being a big operation, would have you know, plenty of attorneys and be able to sustain a lawsuit to defend various aspects of things. But I think it's really essential that journalists who are working with whistleblowers vigorously and zealously defend the protection of the identities of their sources. And even in the process of, you know, discovery, defend the protection of the identities of their sources. You know, they often have to end up, you know, defending themselves against slap suits that may come from their participation. And I think they also have a role to play in verifying the authenticity, of course, of the evidence and explaining the evidence, and in a way can provide some level of sort of a buffer for the whistleblower. So I think that there's various tools and things that they are almost compelled to do, whether or not they have the resources. And I think that's where sometimes things can fail. But this is something that's coming up increasingly. And I agree with Mary, in an ideal situation, the whistleblower's tip gets, you know, verified and cross-supported by so many different pieces of evidence and witnesses that their testimony becomes necessary and irrelevant.
Thank you. Christos.
Thank you very much. What I would like to add is that during the court proceedings, we have an additional right for the defendant in our European system, the right to confront the witnesses. And this is the right which derives from the Article 6, paragraph 3.d of the European Convention of Human Rights. And this is a key issue for the court proceeding, for the main trial. And I do not have any special idea how we can overcome this obstacle in this case, because it is a matter of domestic law many times, how this is solved. But this is an additional problem, let's say, for the prosecutor in order to prove that the perpetrator is to prove who is the perpetrator of a crime. And so the problem is that we should have compensatory factors for this right in the pretrial stage, as the European Court of Human Rights has said. But I don't know how we could solve this problem at the pretrial stage, since the whistleblower does not want to present himself. So this is an outstanding issue and an additional issue of the trial. Thank you.
Samantha, you wanted to respond?
Yeah, I think that's a good point, and that it's just respond to what Christos said, that there's often even up to judicial discretion to decide, to what extent the confidentiality can be protected of the whistleblower, and to what extent to have closed proceedings. There have been instances, for example, survivors of gang rape cases during war crimes, where the victims have had bags over their heads to just conceal their image, but allow them to be physically present and in court, and to use voice changing technology to also change their voice so that their perpetrator, can't identify them, but to allow them to testify in court, and to also, protect them in an open proceeding, for instance, where they may be known to the perpetrator and the court, but not necessarily known to anyone from the public who may be proceeding to protect their identities. So I think that it's important that courts have many different tools in their toolkit available to have different levels and options for protection, to make people feel safe and comfortable when they're speaking out against someone who's more powerful with more resources. And so I think that is one potential option, with the other, which I think has already been said, just the duty to warn people of the limitations from the very beginning, so they can decide whether and to what extent to even participate, knowing that the judges have some discretion and they may decide to give some protection later, but they also may not, and they have that full authority to do that, and people should be well aware of what they're working with.
Thank you. In our last few minutes, I wanted to sort of wrap together kind of questions 6, 7, and 8 as really thinking about professionals who are engaged in the matters that are the subjects of leaks. And so I'll sort of break it into 3 parts. but drawing it all together is the fact that these are professionals really who are involved in all of this. First question is, how can investigators work with banks and financial entities that may either be involved with or have information about the subject of the disclosures? What challenges do investigative bodies face if they're trying to take legal action against professionals who are implicated in malpractice, as reflected in the leaks? And then finally, do leaks prompt professional associations and licensing bodies to sort of change their own rules? Right. So do we see that as a fallout? So really, it's thinking about professionals in these three ways. So you can pick up on any of that that you'd like to speak to. Any thoughts? I know you've been stalwarts to last this long in our session, but just as I said, wanted to sort of think a little bit about the professionals since they play a role through so many of these scenarios brought through leaks. Samantha?
So I just want to flag for folks who haven't looked at the questions and answers section that I think in large part have addressed this in writing in the answer section. But just to say that professional associations, especially the international ones, are dealing with professionals in different jurisdictions. And even like in the case of the United States, you know, if you're a lawyer, for instance, you're governed by the state bar association, and they all have slightly different standards. So I think the crux of the points that I would make to make a otherwise very long answer short is that these associations have a role to provide resources and knowledge and standards, but never should create an affirmative duty to report, because in many cases the infrastructure, the legal protections and the reporting infrastructure is not available to them. So they should be advised to seek a lawyer and understand the applicable laws and procedures available to them. So there's no one rule that really can apply to everyone in every context. But I think that these associations can also be helpful in working with legislators to improve things so that there is legal protections available for when someone whose kind of job it's like duty speech, right, as an auditor or a lawyer, a tax professional, is going to come across this. So there's a role for legislators here and for professional associations in advocating for improved legislation as well. So I also think that there is a role to play in condemning acts of retaliation against people from the different trades who are reporting something in the public interest in certain situations, and to speak on that and surround them with support as well.
Thank you. Tom?
Inconsistencies between professional standards and statutory free speech rights, particularly with respect to lawyers. There's no lawyer loophole in any of the U.S. whistleblower laws, the Whistleblower Protection Act, or any of the corporate laws. They're engaging in protected conduct. Unlike the EU Whistleblower Directive, where the privilege has statutory authority.